Good afternoon, everyone. Welcome to the monthly Parkinson's telehealth program. It's a wonderful day, and it's wonderful to see all of your faces here today. There's so many things I want to say, but this presentation is important, so I want to get to it really quick. Let's see, on the screen on the screen is information about the Parkinson's Power Summit that's coming up September 6th. If you can make it, we would love to have you there. It's going to be a great program. We're very excited. It's all about empowering our Parkinson's community. And so family, friends, providers, hope you can come. The registration will be up in June. I'm not going to give a date because then I have to follow through and have an exact date. But it will be soon. There's a couple things in the room I'm going to talk about really fast in the room, but we have a couple here who have been married for 50 years as of Saturday, Arlene and Ivan. And if you ever have one of those going on that's close when you're here, you have to tell me because we have to celebrate all the good things, and that's definitely a good thing. And they have beautiful corsages on. This weekend, if you didn't get to go, there was this really great event called the Festival of Speed. It's 100 vintage race cars came out to Spokane Raceway Park, and they raised a bunch of money to help continue providing programs like this. And so they're planning it already for next year, so keep your ear out. Even if you don't like vintage race cars 363 days a year, it's pretty fun for those 2-3 days. So hopefully you can look forward to coming to that next year. And we just want to thank everybody that's part of that, and that's a really long list, and so I won't do that today. I have for the Spokane location, first I have passed out a couple of pieces of information that Mr. Sayre has given us for the presentation. They're pretty long, which is good. One is 6 pages and one is 12 pages. So our outlying locations, you let me know how many copies you want after today's presentation, and I will get those to you. So call me at the PRC at 509-473-2490 or email me at center@SpokaneParkinsons.org, and let me know how many of those you want, and or if you would like one of those, and I'll get that out to you. And I think for right now, that's all I can think about. Go ahead, our outlying locations, please mute your mics. We're going to keep our mics muted until the end of the presentation, and we'll do our question and answer after that. And I'm going to let Mr. Sayre introduce himself because I'm just going to. But this is Mr. Dick Sayre, and we're so thankful to have him here today. I do want to say one really quick thing. This was precipitated by a request from somebody who said, Cindy, we really need to have this information. And not just because I really agree. I sought out Mr. Sayre and asked him to come. But if there's any information and presentations that you would like to have in the future and you're not seeing them, let me know. And I'll do my best to get somebody in to do one of those presentations for us, okay? So I'll stop talking and get out of your way.
All right. Turn off my buzzer here. I apologize for my throat. I'm allergic to pine pollen. And you can imagine how much fun this time of the year it is for me. But anyway, I'm here. There are some materials that I think everybody here has. I don't know if the rest of you have, but in addition, I'll refer to these outlines, which at some point I'll talk about towards the end of this. These deal with Medicaid and Medicare, and for those of you in the outlying communities, Cindy will get you a set of these if you're interested in them. She's making sure everybody's got one here. It basically is an outline of Washington Medicaid. So for those of you who aren't in Washington, it'll be of some help. But Medicaid is somewhat standardized throughout the country. There are different rules in different states, but for the most part, the basic rules are the same. we're not really going to talk a great deal about Medicaid today. I'm happy to answer questions. I am going to talk about estate planning, which is what apparently is the hot button. And estate planning around disability is a very different kind of estate planning than estate planning for people that are not dealing with that issue. And so we're going to talk a little bit about the kind of things we do in my work, and especially when we're dealing with disability issues. The most important issue that we address typically are things like powers of attorney and methods by which you can make decisions for someone else. Wills are important, and in the area of disability planning, they are typically more important than they are anywhere else. If my wife and I have a will and I die, my estate's going to pass according to my will. If we don't have a will, the likelihood is that my estate will pass to my wife. Karen and I have been married since forever, and when we got married, we had a Vega. So everything that we own is community property. And under our law, if in the state of Washington, if I die, my wife inherits all of my community property and half of my separate property. Now that little thing I just threw in there can be a surprise for people who are in a second marriage. Sometimes they'll be in a second marriage and they'll think, oh, it'll be fine when I die, it'll go to wherever I want, to my kids. Not so. It'll go to your spouse first. Community property will go to your spouse. And then to the extent it's not community property, it's separate property, it'll be split between your spouse and your kids. So for people that are in second marriages, having a will becomes very important. But it's more important in the disability context than it ever is in inheritance. So we'll talk a little bit about why in a minute. But for most people, when we deal with disabilities, and frankly for most people, the most important document is a durable power of attorney. So we're going to talk a little bit about that. You've got some information in front of you. The outline is blissfully simple. It's not very detailed, but it helps you understand a little bit about these documents. I have to sip coffee now and then because I took a decongestant and it's drying out my mouth. But it's better than having me snoring away up here. So the outline talks about durable powers of attorney. And there are different kinds of powers of attorney, so you're aware. There's something called a durable power, a general power, and a limited power. If you went to a stationery store and bought your durable power of attorney, or you got one online, what you have probably is not a durable power at all. It's probably a general power of attorney. I'm fond of saying that you get what you pay for, and if it costs you $1, it's worth $1. If it was free, it isn't worth anything. It's kind of a good notion, right? I have a lot of clients who come to me and they've got Medicare supplements that are free. And they say, isn't this great? This Medicare supplement is free. And it's great right up until they go to the hospital. And then it's not so great anymore because it's free. And because it's free, the benefits are pretty limited. And you get deductibles and you get all the rest of it. And they try to boot you out of the hospital and nursing home as fast as they possibly can. And so, with all things in life, if you get it for free, it probably is worth what you paid for it. So the most common thing I see when I deal with people that come to me are powers of attorney that they have got themselves, either online or at a stationery store. And those are called general powers of attorney. A general power of attorney says that Dick may act for Karen, and I can transact business, I can buy and sell property, I can do all kinds of stuff for Karen, as long as Karen is competent. As long as Karen is competent, I can act for Karen. That's a general power of attorney. And as long as Karen is fine and she's fully competent, I can act for her. The moment she's not fine, the general power of attorney ends. That's not something people realize. Yeah, it ends. Because it draws its authority from the principal. It's an agency relationship in law, and it draws its authority from the principal. And if the principal loses capacity, the relationship ends because she can't undo it. She can't give me direction anymore. So a general power of attorney is great as long as Karen is competent or I am competent. The problem for people that are dealing with disability is that's exactly what you don't want. I mean, it's nice to have it. You can go down and do banking for your spouse if you want. But when they reach the point where they're no longer legally competent, this document will terminate. And the purpose of the power of attorney when you got it was to take you past the point where the person lost capacity. You don't want to have to do a guardianship. You want to be able to manage money, right? And that is a durable power of attorney, not a general power. And the problem is if you buy one of these things at a store, it typically has a bunch of boxes on it. And it takes about 4 checks to make it a durable power of attorney. And so what people bring me is general powers, and they've checked 2 of the 4 boxes, and that's what they have as a general power of attorney. They haven't gotten to the place where they've made it durable yet. And, it cost them $1, and so I'm minorly sympathetic. But what they end up with is the wrong thing. The other kind of a power of attorney that we do a lot of is called limited powers of attorney. A limited power of attorney lets me give authority to somebody else to do something. So, for example, I can say, I'm going to go to France, which would be a nice place to go, and I'm going to be gone for 2 weeks. And during that time, I want my daughter, Wendy, to sell my car. Okay? So that is a limited power of attorney. It's limited for the 2-week scope, and it's limited to sell the car, right? And it can carry on past my return. I can give her a limited power of attorney to sell the car whenever she can, but it is limited to scope and purpose. Realtors use them a lot. Builders use them all the time. If Karen was a house builder, every time she finishes the house and has to sell it, she has to have me sign off on the deed because it's community property. If I give her a limited power of attorney and I say, you may sign my name on these deeds as you develop the property, she just signs my name and sells the property. And that's very common amongst builders and realtors because otherwise they have to have their spouse show up every time they do closings. So limited powers of attorney are commonly done in some professions. They're rare except for the example I gave you outside of that arena. The general power is the most common, and then the best of the bunch is a durable power of attorney. Most people that have lawyers draft your documents for you have durable powers of attorney. And the difference between a general power of attorney and a durable power of attorney is that a general power of attorney terminates when the principal loses capacity. The durable power is unaffected by that change. Sometimes they are called springing powers, which means they spring into effect when the principal loses capacity. Others are called shifting powers, which means when I sign them, I shift the authority to you right now. And a lot of that's a function of how long you've been married. If you come and meet me and I say how long you've been married and you can't remember, then I figure it's fine to have a shifting power. Because you've been married so long, the likelihood of getting divorced is way past. You've already been through the valley of the shadow of divorce. You've come to the conclusion it would cost way too much to get divorced. You're not going to do it. Whether you like the person or not, you're still not going to do it. So you can have a regular old durable power of attorney, which when signed gives you the authority to act. In my family, Karen has a durable power of attorney for me that's effective when I signed it, because the day I signed it, I was going in to have back surgery. And I said, because she had to close on a house that afternoon, and I said, it would be really important for you to call the hospital and make sure I'm not dead before you sign the papers, right? Got it. But her power of attorney to me is a springing power because she wasn't closing on houses or anything. And we really don't need for me to act for her any more than we need for her to act for me, except on that one occasion. We just never adjusted them, fixed them. It doesn't really matter to us. But I ask people how long they've been married, because if you've only been married for a few years, a durable power of attorney gives the attorney in fact, which is the name of the person that acts for the principal. That's your legal title, is attorney in fact. The power to act for you, and that includes take your money. So if you've been married for 3 years, you don't want a shifting power, because I don't want you to come home from a hard day at work and have a note on the refrigerator that says feed the cat at 6, the kid at 7, and I'm in Guatemala with all the money. Bye, right? And that would happen, it could happen with a durable power of attorney that was effective when it is signed. But for people who have been married forever, it doesn't make any sense. And if you're dealing with disability, it doesn't make any sense. What you want is a durable power of attorney that's effective right now, so I can act for Karen right now. If she needs something, I can do it. I can deal with doctors. I can go to the bank. I can do whatever I got to do. And so typically for people that are dealing with disability issues, you want a durable power of attorney. That, in my mind, is almost more important than the will. I mean, the will is important, but the durable power of attorney is how you access things like Medicaid, and Medicaid will keep you from going broke. Kind of an important thing, right? So let's talk about durable powers of attorney. First, they are essentially a substitute for a guardianship. I don't dislike guardianships. I do a lot of them, and there are times when they're appropriate. But for people who've been married forever, they're a huge waste of money. If Karen had to become my guardian, it would cost about $3,000 for that experience. And she'd have to post a bond with the court to convince the court she wasn't going to steal her money. And she has to do an annual accounting every year and an annual care plan. Now, that's fine if the person that's my guardian is not my wife, right? If the person that's my guardian is professional, maybe I've got a child who I'm not all that trusting of, although if that's the case, I generally don't have them be fiduciaries. A fiduciary is the word we apply to people who handle your money for you. But if it's not somebody who's an immediate family member, typically I will appoint, I'll have bonding and blocking and the sorts of things that come with guardianships and accountings, and that's okay because I don't want anybody stealing my money. But I'm not terribly concerned about it if my wife steals my money. It's okay with me. People say, what's your estate plan like? What'll happen if you die? And the answer is, I'm going to leave it all to Karen. And they say, well, what if she remarries? And I said, well, I'll be dead. I don't care. Good on her, I'll be gone. So it just depends on kind of your personal outlook of life. You can tie up money for people forever if you want, but most people don't. Well, then that's not a part of most people's estate plan. But if she doesn't have a durable power of attorney for me and I lose capacity, her only option is to become a guardian. So if she petitions the court, and the court appoints her as my guardian and gives her the powers to manage my money and make health care decisions for me and all the stuff that goes with being a guardian, and she then has to account to the court annually. She has to do a care plan typically in this county once a year. She also has to post a bond so that if she steals my money, the bonding company will get it back for me. Now, isn't that very workable for a couple? And contrast that to a durable power of attorney where Karen simply has a document I've given her and it says, trust Karen. She's going to manage my affairs. Trust Karen. And so for most people, it's a durable power of attorney. If you want it to spring into effect, you want the minimum amount of trigger. For example, I see durable powers of attorney all the time which require 2 doctors to certify that I've lost my marbles. That's the expression we use in the trade, that I've lost my marbles. And once the doctor said Dick has lost his marbles, he can act. But there are a number of durable powers that I see that say 2 physicians must sign affidavits or certifications to trigger the springing power. Can you imagine what it takes to get 2 physicians, 2 different doctors to sign affidavits? I mean, it takes an act of not just one God, but 2 or 3. It's, just getting to the doctor is hard enough, but having them sign affidavits is even harder. And so on those kinds of powers of attorney, and typically they come, if you have a trust that was created for you by one of the trust companies, if you read the triggering power, you'll see that language. That to me is too stringent. It's impossible to trigger them. And, Diane and I have trotted up to doctors' offices all over town, with notaries in tow, and find the doctor, wait, have the doctor sign the statement. Then we trot off to another doctor, notary in tow, have another statement signed. The clients are in there waiting. We resort to flowers and all kinds of things to receptionists. It becomes very difficult to get these standards met. And there's one attorney in this city who creates a durable power of attorney for health care that requires a certification from 2 doctors, and a durable power of attorney for money, which requires an affidavit from 2 doctors. Those are different. So can you just imagine the horror that we go through to get these things triggered? What I do is I have kind of a lesser trigger, and the lesser trigger is if my attending physician says I no longer have capacity to manage my affairs, my attending physician may sign a letter, and that will trigger the power. Simpler. And you can always push back on that if it doesn't appear that I really have, that I still have capacity, push back on it. But for the most part, my advice to people is do not name anybody in your power of attorney you do not trust implicitly with your money. Never put anybody in that document who you wouldn't trust with your money. And I've learned to ask questions. A number of years ago, I met with a woman who said, I want my son, he's a wonderful boy, I want my son to be my power of attorney, he'll be great. And, how many kids have you got? I got a son and a daughter. Okay, well, tell me about your son. I've learned to ask these questions. And she says, well, he's just a wonderful boy, and he just got out of prison. Okay, what was he in prison for? Embezzlement. Okay, he's a perfect person to handle your money, don't you think? And I said, what does your daughter do? Well, my daughter's a CPA, but she's in Chicago. And this is a mom who's primogenitor. The son rises and sets on the boy, right? The daughter is back in Chicago someplace. Well, I convinced her that probably the daughter would be the better choice to manage her money as opposed to the embezzler. And she kind of came around to that after a while. And so I've learned to ask these questions. But you wouldn't want to put anybody on your power of attorney who you wouldn't trust. So if you trust them, having the doctor's letters typically is fine. You can also make them effective now. And oftentimes, especially with people that have disabilities, if you come to me, I'll make them effective now. Because the spouse who is not disabled needs to be able to go to the bank tomorrow. They need to be able to deal with insurance companies. They got to be able to deal with DSHS. They got to talk to doctors. They got to do it tomorrow. And so those powers of attorney are effective when they are signed. There are a number of powers that these things authorize. But basically, they're a substitute for a guardianship. You don't need a guardian if you have a durable power of attorney, because the durable power of attorney can do everything a guardian can do. Everything. The durable power of attorney can name successors. So in my durable power, I named Karen. If Karen can't serve, I name my daughter Wendy. If Wendy can't serve, I name my daughter Tracy, right? So if Karen is operating as power of attorney and Karen becomes ill, Wendy takes over. And if Wendy becomes ill, Tracy takes over. So I can set myself up not to need a guardianship down the road. You can't use Wendy or Tracy if Wendy or Tracy is an embezzler, right? You got to remember this. But assuming they are not, you can use family members, you can use friends, you can use banks. It's very common that I use a bank. I met with somebody the other day, and she's not comfortable. She loves her kids. They're all very responsible, except for one, but they're having a little tiff with this one right now, and she doesn't want the tiff to screw up her family. Basically, she says, I don't want to destroy my family over who's going to manage my money. So the attorney, in fact, in that case, is Washington Trust Bank, who's fine with doing it. So Washington Trust Bank will be the power of attorney, and if she reaches the point where she needs help, the trust department will step in and pay her bills and manage her money and take the kids out of it. When she dies, they'll get their money, but not until then. We can empower the attorney, in fact, to make deathbed gifts. We used to do a lot of that. We don't do it as much as we used to. But if you remember years ago, you could make a gift of $10,000 per person per year, and nobody cared. $14,000, and it's what that is a reporting threshold, and it's an IRS thing. And the IRS says if you give away $14,000 or less per person per year, we don't care. You don't have to report it. We don't care. So you don't have to tell us, because otherwise we'd all lose our mind. When I was first in practice, there was no de minimis amount, so you were giving your kids $200 and we had to report it. So finally the IRS said, no, raise the ceiling. We're not interested in all these small gifts. And the effect of a gift that's under that is that they don't care about it. DSHS does care about it. Medicaid does care about it, but the feds don't. So you can give 10, in those days 10, now 14,000 per person per year without reporting. So I can give 14,000 to my two daughters. I can give 14,000 to the mailman. I can give 14,000 to Eric back there. I can give everybody in the room $14,000 in any tax year. Now, why would we want to do that? The estate tax ceiling in the state of Washington is $2 million. The estate tax ceiling in the federal government is a little over $5,300,000 right now. If you have an estate that exceeds these amounts, it will result in estate tax. So what if your estate is $2,050,000? Well, if you have 5 kids, I can get you below the tax threshold with a series of gifts right now, right? I can give $14,000 away per person to enough people to drop you below $2 million. So when you die, your family doesn't have to pay estate tax. And that's a deathbed gift, and you can do that through powers of attorney. We used to do a lot more of them back when the ceiling was $600,000, right? We did a lot of that, especially with farmers, because the farm ground would be worth a fair amount of money, and the farmer wanted the farm ground to be in the hands of his kids. And so as he was coming to the end of his life, we'd start making a whole bunch of gifts for the kids to get the state down below the taxable ceiling. The problem for farmers is they don't have any money, they've got dirt. And anybody here is a farmer, you know that. The moment you have enough money, you buy a combine, or you buy the neighbor's property, or you buy something. I mean, typically, farmers will buy contiguous property if they can get it, so they don't have to drive their combines over the roads. So they buy stuff with the money. To a farmer, dirt is money. That's production, it's money. So they typically don't have much money. They've got a lot of ground, and the problem is when you're dealing with things like disability or estate tax, the only way to generate money is to sell the ground. And so for families that are coming to the end of someone's life, if we're worried about estate tax, there isn't a lot of cash in the estate. The only way to get the cash is to sell something. And so in that case, we might look at deathbed gifts to get below these ceilings, so we don't have to sell anything. We can authorize investments. We can authorize medical decision-making in a durable power of attorney. And in our office, we typically do two. We do a durable power of attorney for medical decision-making and access to medical records. We have to deal with HIPAA and all the confidentiality laws, and we build that into our powers of attorney. And then we do a power of attorney for money. So typically we have one for money, one for health care, and never the twain shall meet. The doctor doesn't care about your money, right? The bank doesn't care about your health care. But sometimes I'll do them combined. If people call me and they say Fred is, his capacity is borderline, and if you hand him a giant stack of documents, you'll overwhelm him. And if that's the case, I'll put them together. So you'll get a durable power of attorney for money and health care, which I'll explain to Fred, but he doesn't have to deal with 40 pages. He only has to deal with 8. And so you can do it either way, but the effect of this particular power is I can get authority to make health care decisions for Karen. Durable powers of attorney do not take away my right to manage my money nor to make health care decisions. They simply appoint an agent. That's an important distinction. So in a durable power of attorney, I'm giving Karen the power to make decisions for me. I still retain that authority. I can say, no, that's not what I want you to do, and my say is the final say, because I'm the principal. I'm giving her my authority to act for me, but it always comes back to me. So if I'm in the hospital and Karen wants to do something that I don't, they're not going to do it. I'm assuming that I am in my right mind. If I'm not, then she may be able to overwrite me, so to speak, and say, no, he's got dementia and he needs to have this care. But typically in a durable power of attorney, I'm authorizing someone to act for me, and I can withdraw it. And I do that periodically. People will call me and they'll say, my son, upon whom the rises and sets, the embezzler, is stealing money from me. And then what do? We terminate the power of attorney. I just did that last week for a woman whose nephew put himself on a $500,000 bank account. Isn't that nice? So he's off it now, and his durable power of attorney was terminated. So it ends. In a guardianship, they take away my right to make the decision. So if I'm in a guardianship, I lose my right to marry, to contract, to deal with my bank, to make healthcare decisions. They take those rights away from me because I'm incapacitated, and they give it to somebody else. And somebody else may be my spouse, my daughter, a certified professional guardian, a bank. Somebody else takes over for me. But I no longer have the authority to say no in a guardianship. That's the big distinction between the two. And so for those of you who are listening to this, if you don't want to have your decision-making taken away, you want durable powers of attorney. Because you can say, no, I want to be part of the discussion. If you have a guardian, you're not part of the discussion. The guardian is going to do what he or she thinks is best for you. And they have to do what's best for you. But you don't have a voice in this, really. Where if you have a durable power of attorney, you can say, nope, sorry, not going there. So you have a far more active voice in what's going on. So typically we do a second one for medical decision making, and it's focused on everything from surgeries to consent, informed consent, to funeral, to you name it, I've got it in there. So that the attorney, in fact, the person's operating their healthcare decision, I've got everything in there. I even have a driving provision in there that says if the attorney, in fact, thinks that mom shouldn't be driving anymore, he can take away her driver's license. That creates a lot of interesting discussions, as you can imagine, especially if it's you. But if you can think of all the people that that shouldn't be driving, this is not a bad thing. And some of us have had pretty good luck with this. My mom sort of gave up driving voluntarily. I went over to see her. She lived in Seattle, and both her mirrors were gone, and there was a big dent in the back of the car. And I said, My mom had a Century that had 48 miles on it. And I said, so Mom, what happened to the mirrors? I'm not sure. Okay. What happened to the back of the car? And she said, well, I must have hit something. Yes, I think you must have. I'll just take the car home now. She said, okay. And so it was easy for me. But she also lived at a CCRC, a retirement center like Riverview, like Rockwood, and so they could drive her around. So she really didn't need a car anymore, and it all worked out. And I took the car home. I took it to the gas station to see if I could make it over the pass. And the guy said, the oil in this is like butter. I mean, does she ever drive it? I said, yeah, she drives it to the grocery store and back, and that's about all. So they had to scrape out the oil and the grease and refill it so I could get it home, which I did. But it really wasn't the car I wanted, but I didn't want her driving it, so it needed to come home. And it got new mirrors before I left. The other thing we do that's pretty critical with durable powers of attorney is we authorize transfers. Now, why would that be important? Let's lay out the story. So Karen and I are going down the road of life, and Karen has a stroke. It's a bad stroke, and I take care of her for a while. She goes to the hospital. If she's there long enough, some of you know these rules, if she's there long enough, she goes to a nursing home for rehab. She has to be in the hospital for 3 midnights for the condition for which she was hospitalized. It's a complicated little formula designed to deny benefits. But if you meet all these tests, the gatekeepers, then you go to a nursing facility, St. Luke's, someplace like that, and they provide rehab services for you up to 100 days. And at the end of the 100 days, they sit you down, or whatever period. Most people get about 20 days, in truth. They sit you down, and usually when you enter into the facility, everybody's running around in sports shirts and welcome to our facility. It's great. And on about the 70th day, they sit you down. They're all in white jackets, and they say, we're going to decertify your husband, which basically means Medicare is going to stop now. And you can appeal if you want, but your chances of winning are somewhat remote. Depends on why they're decertifying. But when that happens, you lose Medicare. And then the nice person next to the nice doctor who's from the billing department says, how are you going to pay for this? And then you say to yourself, pay for this? But what do you mean pay for this? We have Medicare. We have a supplement. Medicare does not pay for long-term care. It does not pay for anything but skilled nursing, and only to 100 days. If you're lucky enough to have TRICARE, you get more. People with TRICARE should never let go of TRICARE, because TRICARE has better benefits than Medicare does. But even TRICARE is limited. It only pays for skilled care. So even with TRICARE, if you're on the 150th day and you're no longer in need of skilled care, you won't get it anymore. It's just skilled care. Medicare stops at 100 days. And so then Karen who's had the stroke is moving to Unhappy Acres. I used to call it Happy Acres, but I don't anymore. So she's off to Unhappy Acres, which is a rest facility, a nursing home. Or maybe she's coming home, and I need help in the home. And I now get my first blast of what it costs to have somebody in a nursing home. The nice people over at the vet center or somewhere else say, vet center is probably the most reasonable of the bunch, and they're only $8,000 a month. Riverview is about 12. St. Joe's is about 10. And so people go through this, not only are they being told they're losing Medicare, they then are told it's going to cost $10,000 to $12,000 a month to take care of their loved one. And they have $250,000 in a house. Oh, that's about a year and a half, maybe 2 years, and you're out of money. And so the only way that you can create eligibility that you can survive, the well spouse can survive, is through a program called Medicaid. Medicaid will pay for that person's care if you jump through all the hoops necessary to qualify for Medicaid. And there are a lot of hoops. I'm fond of saying that any program that requires a lawyer to get you into a welfare-based system is probably not working so good. But it is a complicated process. But if you get into Medicaid, Medicaid will pay for Karen's care. And Medicaid will pay for home care for Karen. It'll pay for facility-based care, adult family home, congregate care, and it'll pay for nursing homes. But the only way I can do that is by taking money that Karen owns and putting it in my name. So that means I have to be able to transfer her money into my name. I have to be able to cash out her IRA and put it into my name. I have to put the house into my name. And if I do all that stuff, then Karen, as long as Karen has less than $2,000 and the money that I've put in my name is sheltered, and there's ways we can shelter this money so that Medicaid doesn't count it, and that's a whole other topic, but if the money is sheltered, Karen will qualify for Medicaid, and the state will take her Social Security and offset against her cost of care, but they'll pay the cost of care. So they get the Social Security and they pay the rest of it. Not everybody wants to be on Medicaid, and that's certainly fine. I have a number of clients that don't, and they'll go for a long time. I mean, they'll start out with $1 million, and they'll say, I got plenty of money, I don't want Medicaid, and they'll be back in about 6 years, and they'll say, well, now I'm down to $250,000, $300,000, and Medicaid's sounding pretty good, because pretty quick here I'm going to be all out of money. And so Medicaid's available for you if that happens to you. And you can either get on it early or you can wait. It's up to you. In my work, I tell people what their options are, and they have to decide. I have lots of clients that have a lot of money, and Medicaid is the last thing they want. I have people that have a philosophical objection to Medicaid, which is fine. But at some point, if you run out of money, you run out of money. And Medicaid was there to keep you from totally running out of money. And eventually people will say, okay, I give up. I need to ask for help, and that's what it's for. But to get it, you must be able to transfer assets. I got to be able to take Karen's money and put it in my name. And the only way I can do that is through a durable power of attorney or a guardianship. The only way I can do it. So if this happens and something awful happens, then I've got to be able to get that money, and I can do it through a durable power of attorney. So I keep coming back to this important document. Eric's got his bicycle T-shirt on back there. I ride a motorcycle, and I belong to. I've got this T-shirt, and it says "Sons of Arthritis," and it shows the sort of skeleton on a motorcycle, and I belong to ibuprofen chapter. And I got 2 shirts from my rheumatologist, both of whom think it's pretty funny. But the problem is, I can hit a piece of pea gravel just like Eric can, and I will be on Medicaid. Right? I mean, it isn't just for old people. Anybody can wind up in a circumstance where something awful has happened to you, and you will need respite care or rest care or facility care or St. Luke's or something, and you will run out of money real fast if you can't access some of these public benefits. So we do that through things like durable power. So if you get nothing out of the beginning of this discussion, that is the critical document. And if you have one that you're comfortable with, great. If you have one that is old, you should have somebody look at it. We update ours every few years. The laws change constantly. The laws on one of the things we do in our work is a lot of special needs trusts. The special needs trusts change every 4 months. The laws change every 4 months. Medicaid is no different. Medicaid is going through great upheaval because of the Affordable Care Act, right, which is including more people and expanded Medicaid, and so they're changing all the rules to go. We now have something called MAGI Medicaid, and in some ways it's magic, but it's a different kind of expanded Medicaid, so the rules are all changing again. So those of us who do this stuff, you have to just rewrite there because it's always changing. But we do everything we do through powers of attorney. The other thing we do when we transfer is we avoid liens. Medicaid has the right to come back to collect the amount of money it's paid for your care. So if I'm in a nursing home and Medicaid's paid for me for these 10 long years, when I die, they take my house, right? Because they want to be repaid back. If I have money in a bank account that was made otherwise inaccessible to them, there are ways to do that. Or if I have a car, they want the car. They want to be paid back. The exception to the rule is if I put my house in my wife's name, they cannot get the house. So if in the course of these transfers I put the money in Karen's name, I put the house in Karen's name, I put the cars in Karen's name, and I die, there will be no lien. So that's important. And so people sometimes will not do this. I deal with a lot of clients who will spend down. The well spouse is allowed something called a CSRA, or a Community Spouse Resource Allowance. In other words, they're allowed to have some money. And they will spend down to this CSRA level, and they will apply and get Medicaid. No problem, because they fit into the criteria. But when their spouse dies, DSHS will lien the house. Because the house was in both names, it was never transferred. And then when the well spouse dies, DSHS will collect. The kids will lose the house, essentially, or at least half the house. You avoid this by this transfer process, and you do it by means of a durable power of attorney. So I give Karen the power to sign a deed, to transfer the house from me to her, and thus we avoid these things called estate recovery liens. So it's important for a lot of reasons, and that's just one of them. The other thing that it's important that we do with these is we can authorize the attorney, in fact, to cancel a community property agreement. Now, those of you who don't have community property agreements, in Oregon, for example, sorry, you're all separate property, you should move. But those of us in Idaho and Washington, we do have them. I think Montana does, but I honestly don't know. I don't practice in Montana. I use lawyers in Montana that do practice in Montana. But Washington has a document that allows me to give my estate to my wife at death for $75. So we sign an agreement. It's called a community property agreement. And it says, turn everything into community property when Dick dies and give it to Karen. Okay? And then it's recorded when I die, not before. It's recorded when I die. And the effect of it is the house transfers to Karen, the car is transferred to Karen, the bank account's transferred to Karen, everything moves to Karen. And it only costs, it's $75 plus a couple dollars for this extra recording fee. So I think the net is $79. But the effect of it is that when she files that, the probate is over. $79 probate. Great. And it is a good thing for everybody who doesn't have $2 million. Right? Remember, if you have $2 million, there's an estate tax. And they tax the estate at the second to die. So if I'm worth $1.5 million and Karen's worth $1.5 million, the community property agreement will make her worth $3 million, and they'll tax when she dies. So it isn't for everybody. But if you have an estate, combined estate of less than $2 million, this is a slick deal, right? But what if you're dealing with a disability situation? Dick is disabled. Dick and Karen have a community property agreement. Karen puts all the money in Karen's name, and then Karen dies. The community property agreement does what? Gives it all back to Dick, right? And Dick can only have $2,000 to stay on Medicaid. So Dick must now spend the entire estate down until he's stone cold broke, and then Dick gets back on Medicaid. So one of the things we authorize with durable powers of attorney is the ability to cancel community property agreements. And we do it a fair amount when we're dealing with disability. A lot of people have them, and Karen calls them the imminently forgettable document. People have them. They don't realize they have them. We meet with clients all the time. We say, do you have a community property agreement? And they say, what's that? I say, is it in my will? I think so. And so I'll say, go back and look through your stuff. And sometimes they find it. Sometimes they don't. And what we do then is we go to the recorder's office and we find it because it was recorded. In the old days, lawyers recorded them. You don't have to record them in Washington until death. So we find it, and then we unrecord it, basically. We terminate it. For those of you in Idaho, Idaho requires the community property agreement to be recorded prior to death to be effective. Different rule in Idaho. But you can still revoke it while the two people are alive. It's a contract. It takes two people to get out of it, two people to get into it, either way. But if you give me the authority to sign for Karen, I can sign for her and revoke the power of attorney, or the community property agreement, and avoid that outcome. Okay? Lots of information. It also allows management of other monies, of trusts, and all kinds of stuff. So the kind of document that most everybody needs, disability or not, is a durable power of attorney. It allows you to manage the money for the other spouse. And if you're a child, it allows you to manage the money for your parent, and it avoids the cost of a guardianship. The exception is if you don't have anybody you trust, don't do this. Right? I mean, I've dealt with a number of people with durable powers of attorney where family members steal from their parents or their relatives, and they can do it with durable powers of attorney. So it depends on the people. But I can tell you that's not where I have the most issues with theft. You would think it would be, but it's not. Most of the theft I deal with is computer theft. The kid gets on the bank account with mom, and now the kid can access the money. You don't need a durable power to do that. You just put your kid on the bank account because you need him to help pay bills, and the kid just moves money into that account and takes it out. That's where I see most of the theft today. It's not durable powers. The bankers are pretty good at stopping people that come in and say, my mom is sick, here's my durable power of attorney, can I get her money? They usually say no. But if I get on that account, nobody asks. My mom spent the last 6 years of her life at a nursing home over in Seattle. It was a nice place called Covenant Shores. She had a beautiful view of the lake, and she had a private bathroom. She was quite happy. We burned through all of our money, but it didn't really matter. It's her money, All my friends said, Jick, you're the great Medicaid guru. Why isn't your mother on Medicaid? The answer is it's my mother. It's her money. It's not my money. And she wanted to have a private room with a private bath and a view, and Medicaid doesn't do that. So she was quite comfortable the last 6 years of her life. And what we did basically is I got on her bank account so I could pay the bills. And one day I went to the Washington State Employee Credit Union, and I said, my mom is at Covenant Shores. I need to be able to pay her bills. So they said, okay, here's the signature card. Take this to your mother and have her sign it, bring it back. Sure. So I take it to my mother. She signs it. I bring it back. I give it to him. This account had $400,000 in it, and I was on the account. They never laid eyes on my mother. Really? I mean, it's okay with me. I didn't steal her money. But not everybody is like me, and people do steal their parents' money. And, for me, it was fine. I just opened the thing and transferred to the facility and paid her bills. But it became very clear to me how easy it was to steal money when I went through that exercise, because they never called my mother. They just said, oh, yeah, we know your mother. How's she feeling? Well, she could have been feeling nothing, and she might not have liked me, but it didn't really matter. I was on the account now, and I had access to all $400,000. So, that's where I see the problems. So the other things that we deal with are living wills and health care powers, and I talked a little bit about that, but let me kind of talk about what a living will is. I used to do living wills, and most of them predated 1979. And you may have a living will, and if you do, it's very out of date. If what you have says living will, you need a new one. The living will was a living will because we didn't have any way to deal with end-of-life wishes. So we created a will, and it said, when I'm at the end of my life, this is what I want people to do. The problem with living wills was that we couldn't, at the end of life, we couldn't stop food and water. We couldn't stop nutrition and hydration because the medical community took the position that that is not medical care, it's necessities of life. But people wanted that stopped. I think if I asked you folks, if your brain was dead and you were living in a coma from which you will never recover, do you want them to put you on a respirator and give you artificial nutrition hydration? Most people would say, hell no, not if my brain is dead. What would be the point in doing that? So that the effect of these laws were that doctors wouldn't take away the food and water. So what we ended up with was a law that was passed called the Natural Death Act, which changed the rules. Prior to that, and some of you will remember this, prior to this law, there was an initiative back in the late 70s to allow for assisted suicide. And there was a big fight. The Catholic Church was pouring all kinds of money on one side, and the protagonists were pouring a lot of money on the other side, and it barely failed. It was like 58 to 59 to 61. It barely failed. And the upshot, unlike what we see today, was the two sides got together to figure out what the problem was. That people don't compromise anymore, but they used to compromise. And the agreement was what people were trying to get at was this end-of-life nutrition hydration issue. It really wasn't about assisted suicide. It was about taking away life support for people that were basically dead. And so the church said, well, then we're okay with that. And the medical community said, we're okay with that. It just needs to be in writing. And so the effect was the Natural Death Act. And you can do something that we call a directive to physicians, and it's tied into the Durable Proprietary for Health Care. And it says, if I am in a coma or if I am in a terminal condition from which I will never recover, I direct my family to withdraw life support. Take me off the respirators, and if I don't die, stop food and water, because I don't want to live to be 120. That's not a goal of mine. And we do that through these things called advanced directives, and they're very commonly done. And you can pretty much write whatever you want in them. I have some people that say, if I'm in this condition, I want to have certain levels of care provided. If I pass out, I want to be revived, and then down the road, if I'm never coming back, then do this. So you can kind of write them to fit your circumstances. But they're called advanced directives, and they are not the same thing as a POST or a DNR. So the history continues. The next document we had was called the DNR, or Do Not Resuscitate. And that was a document that said, if I collapse, don't touch me, leave me alone. And it was something you put on your refrigerator, not in your refrigerator, on your refrigerator. And it was a variety of colors. In King County, they were pink. Over here, I think they were green. And they said, do not touch me, leave me alone. I have cancer. If I'm lucky enough to have a heart attack, I would just as soon die of that. I don't want to be brought back so I can die of cancer. Leave me alone, right? The problem is that King County wouldn't honor Pierce counties, and Pierce County wouldn't honor King counties. One was green, one was pink, and people were dying on the border. So, yeah, great. So the legislature came up with an act that said we're going to allow people to do a statewide DNR, and that is called a POST. Physician's Orders on Life-Sustaining Treatment. For those of you in Idaho, it's called a POST. Physician's Orders on Sustaining Treatment. Same thing. I always joke that Idaho is more rural, so we have posts as opposed to pulse. But it's called a POST, and Idaho has probably the best set of laws in the country on these documents, truly. Ours are okay. Idaho's are very well fleshed out, with well done work. Washington, not so much. We have a POST form and something we call the POST paradigm, but it's a little more loosey-goosey in Idaho. But the effect of it is that you can fill one of these things out. Everybody will honor it. And they operate a little bit like a directive, but the difference is that they are for use when you drop, right? So I have a heart attack and I drop. That's where the POST comes in, not the directive. The directive comes into effect where I fall, they resuscitate me, right? I go to the hospital, and then 2 or 3 weeks later, or a week later, they say, he's not coming back. He's done. That's when the directive comes out of the drawer, and it says, okay, Dick said if he was in an irreversible coma, he did not want to come back. But the POST and the POST say, if I have the heart attack right now, stop. And you have a variety of choices. The first one is, if the EMTs show up and I'm dead, do you want me to be revived, or do I want to be revived or not? And that's kind of the first box. And if I'm dead, they just walk away. They put a little flower in my lapel and say, have a good afterlife, and they're done, right? The next level is, I'm not dead yet, radiant levels of care. Then on the back of the POST, it authorizes things like antibiotics, intubation, stuff like that, different kinds of things that are different than just simply bringing me back. The old POST form has changed, and there's a new one that's out right now, just came out. And the old POST form put the antibiotics on the front page, along with some of those other after emergency treatments. And doctors didn't know what to do. You'd show up at the ER and it would say, don't touch me, but give me antibiotics. Doctors say, well, if I don't touch you, I can't give you the antibiotics, so I better bring you back, right? So now we've pulled it apart, and the back side of the POST is antibiotics and that sort of thing. The front side is, this is what we want done if we're in this condition. So, and you put them on your refrigerator, not in your refrigerator. They're green. But more important than anything else, you don't want to POST until you're ready to die, right? Because that's what will happen to you if you have one. You will die. I met with a woman about 6 months ago who was about 34, and she had convinced her physician, after much objection, to signing a POST form for her. The doctor has to sign it, and you have to sign it. So she was proudly showing me her POST. And I said, is there anything wrong with you? No. Well, do you have children? Yes. Would you like to see your children graduate from high school? Why, of course. And you might have grandchildren? Yes. Well, with this green form here, if you have a stroke or a heart attack, which you would recover nicely from, you will not see any of that stuff because you'll be dead. Oh. So this is not a form for people who are not planning on dying soon. If you have cancer, you ought to have a POST form. If you have terminal cancer, you ought to have a POST form. So they don't bring you back so you can die of cancer. Really, that's the way you have to look at this. It's for people who are at the very end of life and have a terminal condition, and who, if they had a heart attack, would just as soon be left alone. That's what a POST is for. It's not for somebody who would come back. And so for most people who are younger, for example, if you have a heart attack, the likelihood is you'll live another 10 or 15 years once they get you to the hospital. Same with strokes. Get the stroke shot, you can do pretty well for a while. So you don't want to POST until you're kind of at that I have cancer, and if I'm lucky enough to have a heart attack, then let me go phase. But it's a very useful document when that time comes. It's green, and you can get them only from your physicians. Okay? So we talked about powers of attorney. Let me talk a moment about guardianships. What do you do if you don't have a power of attorney? That happens all the time. People come to me and they say, my spouse has been diagnosed with XYZ awful disease, and they no longer have capacity to sign. What do I do? For me, the first thing I do is talk to the spouse. Sometimes people do have capacity. Legal capacity is not the same as medical capacity. Capacity for a physician is the ability to give consent to surgery. It's a far greater level of capacity than giving your wife a power of attorney. I mean, if you think about it, to sign a will, you have to know you have money, you have to know who your objects of your bounty are, i.e. you're married and you have children, and you have to know where you want your money to go to. Most people with dementia can do that. Not deep dementia, but most people with early dementia can say, yes, I have a wife and 2 kids, and I want my money to go to my wife, and if she's dead, to my kids. And if you can do that, you can draft a will. Most people understand a power of attorney. Most people have heard of powers of attorney. And if I come out to somebody and they say, Dad's got dementia, and I meet Dad, and I say, this is what we're talking about. Do you understand what a power of attorney is? Oh, yeah, I know what a power of attorney is. Is it all right with you if your wife signs stuff for you? And most of the time, people say, yes, that would be fine. My practice is to go back a couple of times, because sometimes people with dementia have no short-term memory, right? So I'll leave, and the guy will say to his wife, who was that? So the only way that I'm comfortable with this is I'll go back a couple of times, and we have the same conversation the same way every time. So when he's present with me, he knows he wants his wife to have power of attorney. It's pretty clear to me what is intended. So in that case, I can do a power of attorney. Sometimes I can't. I'll meet with people, and the kids will say, Dad is fine, he's great. I get out and meet Dad, and there is no way in the world he could sign a legal document. There's no way. And kind of one of our acid tests is that when we have a conversation with somebody and they appear to be okay, and we hand them a pen, and they study the end of the pen, they don't know what it is, they can't sign. Because they don't have a concept of what's happening around them. But for many people, they can sign. So my first step is, let me talk to them and see. And if they can sign, fine. And it would be a very simple power of attorney authorizing the spouse to make business decisions, pay bills, that sort of thing. But if it turns out that they can't sign, the alternative is a guardianship. In Idaho, it's a conservatorship. And I'm guessing in Montana the same way. I know in Oregon, they have a conservatorship for money and a guardianship for health care. In this state, we just have guardianship, same thing. You have a guardian of the estate for money and a guardian of the person for health care. But what happens in a guardianship is somebody petitions the court to be appointed guardian of the disabled person. The court appoints the guardian, takes away the rights of the disabled person, and vests them in the guardian, who then exercises their rights, pays their bills, makes medical decisions, does what needs to be done to take care of this person. And that is not a horrible thing. It's not necessary if you're married and you trust your spouse. If that's the case, you ought to have a durable power of attorney. It'll save you a lot of money. But if you don't have that relationship, or you're single and you don't really have anybody that you trust all that much, having a guardian isn't a bad thing. The state has a number of certified professional guardians who are monitored by a board, and they come in and they regulate what's going on, and they watch the certified professional guardians. The guardians must file a report every year relative to your health care and your money, and so there's a level of oversight that doesn't exist with family members. So when people come to me and they say, I really don't have anybody, what about my friend? It'd be better to have a guardian appointed, even though it's more expensive, because the guardian really can't steal from you. The guardian has to go to court and do an accounting. Friends can with powers of attorney. So I'm sort of careful about who I appoint in these things. But a guardianship isn't a horrible thing. It works, and we use them if we got no other choices. The court will appoint somebody called a guardian ad litem. Some of you have been through this process. The guardian ad litem is a third party, usually a lawyer, and they are the investigator for the court. So they'll come out, interview the family, find out what's going on, determine whether mom or dad really needs a guardian, are they disabled, and if so, who it ought to be. Then you go to court, there's a hearing, it usually lasts about 5 minutes, and then a guardian is appointed, and from that point forward, the authority is shifted. We do a lot of guardianships for kids who are disabled, intellectually disabled. And the problem I have with that is the hearing only lasts 3 to 5 minutes typically. It's very short. And these kids, they spend all their lives watching Judge Judy, and they get to get out of school, and they get to go to court, and they expect something to happen, right? Something should be happening here. There should be a fight. Somebody should confess to a crime. And so I try to schedule those hearings during the divorce calendar, so at least the kids get to watch somebody fight about, he didn't show up at 5 o'clock to pick up the kids or whatever it is. So they get a little bit of money, something for their money. But for you folks, if you had to go through guardianship, the hearing actually would last all 3 to 5 minutes. It's just like that. You can contest them. People can contest them. So you can say, I don't want a guardianship and I don't like the guardian, and you can have a right to a jury trial to avoid it. And there's a reason for that. If you go to jail, you get out. If you get a guardianship imposed on you, you never get out. So they're very serious about who gets a guardianship and who doesn't. And you have a lot of rights attendant to that. And that can be a problem for families because they'll come to me and they'll say, we need to get a guardianship over my wife, but she will oppose it. Or my mom, she will oppose it because of her dementia. And she has a right to oppose it, even if it's goofy. And you go through this rather elaborate process. And we usually try to find some kind of a compromise because we have to protect mom. But we don't want to mom isn't ready to give up her rights yet, and we come up with solutions that mom can accept, often powers of attorney. So I talked a little bit about community property agreements and how good they are. The other thing I want to talk about is special needs trusts. And in my outline, I talk about credit shelter trusts and special needs trusts. I'm not going to spend any time on credit shelter trusts. I'm going to tell you this. A credit shelter trust is designed to avoid estate tax. Most people that have disabled relatives don't have a taxable estate. I mean, some do, but most don't, because the cost of disability is so high, by the time you're done paying for all the care and the medicines and everything else, you don't have a taxable estate anymore. So most of the people I deal with, especially kids, families with developmentally disabled kids, they don't have any money. They've been spending all their money on their kid. That just kind of goes with the territory. But if you have an estate that exceeds $2 million at the second death, you have to have a will with something called a credit shelter trust in it. And the credit shelter trust avoids estate tax. $2 million is our state ceiling. And that tax is an irritant. It's 17% of the estate over $2 million. It's a lot of money, but it's more of an irritant when you compare it to the federal system, which is 47% of everything over that $334,000, whatever it is, $36,000. That is not an irritant. That's a real tax. So there are times when we have people pay the state tax to avoid the federal tax, and that sometimes makes a lot of sense. But a credit shelter trust splits the estate in half. So it says, Dick says in my will, I say, when I die, take my half of the estate and give it to my daughters and give my wife a life estate in the money. So I give my half of the estate to my daughters. I appoint my wife as the trustee of the trust, and she manages it. She gets all the income off of it for the rest of her life. She decides how it's going to be spent during her lifetime. And at death, this trust goes to my children. So what I've done is I've given my children my half of the estate when I died, subject to a life estate in my wife. Conceptually, that's what I've done. But by splitting it, that money is no longer part of my wife's estate. So when she dies, it's not part of the $2 million. They don't count it. So we can split the estate. We can do it for federal taxes as well. It avoids estate tax for your kids. Most people don't need it. I mean, you have to have $2 million or more, but it can happen. It can be sneaky. I mean, I have people come to me and they say, I don't have $2 million, and they say, I got about $1.7 million, and here's where it all is, and then, oh, by the way, I have a $500,000 life insurance policy. Well, if I die and I leave my wife $500,000, she now has over $2 million, right, at second death. So they may need a credit shelter trust, and this is a device we use to avoid estate tax. And if you have one in your will or trust, it will say in it, family trust or something like that, and it'll say when one of us dies, it splits into a survivor's trust and a family trust or an AB trust or lots of language we use in these things. I call them family trusts, but they're actually called a credit shelter trust. And the reason for that is these numbers I'm throwing out are your unified credit, which is the amount that can pass tax-free at death, and we're trying to shelter your unified credit. So we call it a credit shelter trust. But it does work, and it's very effective for avoiding estate tax. The more important trust that we use are special needs trusts. That's critical. So if you remember, I talked about how important the durable power was. Now I'm going to talk about why the will is important. It's important if you want your estate to go where you want it to go, right? Especially if you're in a second marriage. It'll go all over the place. It won't end up with your spouse. You won't end up with the right kids. It'll go all over the place if you don't have a will. So that's important. It's important to protect your kids. I have 2 daughters, and the oldest one, his name is Wendy, and when Wendy was a kid, she was like spit on a skillet. I mean, raising her was a 24/7 challenge. That kid went around looking for tables that had pointy things to throw herself on. I mean, when she was 2, she would take scissors and stick them in outlets. It was that kind of a kid, And when she was a teenager, it was all I could do to keep the guys out of the house. She was a pretty little blonde, and I had tossed one guy out of her bedroom into a tree one night. I mean, I've got stories. But so this kid, I figured when she grew up would just be a total nightmare. It turns out that her sister, who's this calm, quiet little thing, is the one that has all the issues. Wendy is fine. Wendy's stable and got everything under control, and you never know. But the problem was, if I had died when Wendy was a kid and left her money at 18, she would have bought herself a Challenger or a Maserati or something. She wouldn't have gone to school. Why go to school? I don't need to go to school. I'm rich. I mean, she'd be all done, and the money would be all gone. And if you think about this for yourselves, put yourself back and be 18 in your mind. So you're back at 18 now, and there's a knock on the door, and if you're older, the guy's got a bow tie on. If you're younger, you got one of these silly things, and I say, "Hi, I'm the lawyer for your great uncle Fred. He died. I know you're sad, but the good news is he left you $200,000. Now you're 18. $200,000. For some of you, you could buy a car for $5,000, right? I mean, houses were $10,000. So I'm going to give you $200,000. Are you going to stay in college? Hell no. Are you going to keep your job? Why? You have $200,000. So you'll promptly quit and spend all the money. Wills can stop that from happening. And I used it, and I say wills. Wills are interchangeable with living trusts. Living trusts do all these same things. They are less useful for Medicaid. If you bump into Medicaid issues, living trusts typically have to be terminated. Medicaid and living trusts are not compatible. So typically when I'm dealing with disability, I'm dealing with wills. And so I'm sort of staying in that framework. But the issue then becomes, what about this transfer? I get sick, Karen transfers the money to Karen, and I'm now on Medicaid. So far, so good. Karen dies. If Karen has a community property agreement, it all comes back to me, and I'm out of money. If Karen uses the will that she had before she met me, what do you suppose it says? Give it all to Dick, right? Most of you have wills that do this. Give it all to my spouse. No problem, except that if it all goes back to the spouse, they will never qualify for Medicaid until they're broke. So instead of that, Karen does a new will. And Karen's will says, I leave my money in trust for Dick. And it's called a special needs trust. And it says, Dick can get Medicaid, and my trustee, Wendy or whoever it is, cannot pay money for things that would interfere with his Medicaid benefits. So what will happen is I'll go on Medicaid because I'm now suddenly broke. Right? Karen put the money in trust. I'll be on Medicaid. Wendy will have this money in trust, which she will use to enhance the quality of my life. She can use it to pay for private care. She can use it to pay for private room, better nursing care, dancing, ladies, whatever I'd like. Right? And she can use this money to supplement Medicaid. And then when I'm gone, it goes to my daughters. It doesn't work in a living trust. It only works in a will. There's a set of laws that deal with these that are different. But if it's in a will, this testamentary special needs trust, we call them testamentary because they're in my last will and testament, this testamentary special needs trust will protect that money for me. So if she dies before me, I'll be in the nursing home, but I will have this money, and it'll be protected for me for the rest of my life, and at death it goes to my kids. That's a special needs trust, and it's done typically in a will. There are other reasons to have them. Right now, I'm doing a special kind of a trust that's about a $5,000 fix to a very simple problem. What happened was Granddad died, and Granddad left his money to his children, and if a child died, it said in its boilerplate, if I lose a child, it goes to my grandchildren. And almost all of you have wills that say that. They say, I leave it to my 3 kids, and if a child dies, it goes to their children. What they didn't tell the lawyer was that one of these kids was disabled. One of these grandchildren was developmentally disabled. He never told the lawyer. The lawyer called me in a dead flat panic and said, my God, Susie is disabled. Well, did your client tell you? No. Okay, well, then it's not your fault. He says, that doesn't make me feel much better. No. But the problem is the mother died. The mother predeceased Granddad. And so in Granddad's will, it went from Granddad to the disabled daughter who is on Medicaid, supported housing, SSI, so her income will be stopped, her medical care will be stopped, and she'll be booted out of her supportive housing because she's got too much money, right? Oops. So how do we fix that? Well, there is a fix. It's called a D4A trust, and I'm fixing it. It's going to cost about $5,000 to fix it, and the beneficiary of the D4A trust is the state of Washington. If Granddad had instead said, I leave my money to my daughter and then to my grandkids, except that Susie's disabled, so it goes into a special needs trust for Susie, Susie's benefits would never have been touched. Everything would have been fine. There would have been no $5,000 fix, and when Susie died, it would have gone to Susie's children. Susie actually has children. This way, the children get nothing because the state's going to get it. Oops. So for those of you who have grandchildren, and who haven't thought this through, if you have anybody in the family who is disabled, you need to think carefully how this money from you might get to them. And if it can get to them, you need to trust in your will. And it's really easy to get to them because they may be your heirs. And if they're your heirs and somebody one step up dies, these disabled people will inherit. And that is the last thing you want to do. You know, SSI isn't a huge deal. Medicaid is often a huge deal, and supported housing is a huger deal. So you just don't want to cause them to lose benefits. It's an easy fix. It's cheap. You know, it isn't as good for me because I don't get to make the $5,000, but it's cheap. And you know, in my practice, I'm kind of big on not making a lot of money for the lawyer. I think it's important to try to do it right in the first place, and that is things like this, these special needs trusts. So the last thing I want to talk about was Medicaid and Medicare, and I brought these charts. See my charts. You guys can't see them, but they're nice. These are charts that I give to clients, and the problem for us in our office, for me and for Karen, is that when you come to see us and you say, my husband, my wife, my child, somebody is disabled, and I do what I just did in the last hour and a half rambling through estate planning, only I'm now focused on Medicaid, and Medicaid is even more about putting angels on the head of a pin. It is like standing in a wind tunnel and having me squirt paint at you. It's just too much information, too fast. And so we have a lot of visual aids we use. We have boards that print, and we have these charts. And the charts are very helpful to allow you to go home and try to remember what in the world I said. So the first chart is Medicare. And the only thing, there are a couple things you need to know about Medicare, and then we'll talk a little bit about Medicaid. And for those of you who are out in Washington, this is Washington Medicaid I'm talking about. The rules are similar in other states, but they vary, you know, kind of little bits and pieces. The special needs trust rules are different in different states. But the basic rules are somewhat similar. Washington is more generous than Idaho, for example. And it's more generous in a lot of states because we have Seattle, which is nice. Seattle is our tax base, and so the effect is that Washington has a little bit more money, and they're a little more generous with their benefits. And we also have DSHS, and for all the time that I spend vilifying them, the people that run DSHS have a heart, and they really are trying very hard to see to it that people in need get benefits. And my experience with DSHS at the state level is very positive. You know, sometimes I have big beef with a local worker, but the people that set policy, their policy focus is people in trouble need our help. And it's kind of refreshing to work with them. And sometimes when you hit a wall with DSHS, if you know the people in the structure. You go up a little bit, it'll get fixed. They don't really want to hurt anybody. And sometimes you have to kind of get out of the caseworker and up one or two, and the people up one or two will say, whoa, 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 the big picture is that this person needs help, and we'll figure out a way to get her help. And so my experience with our DSHS is very positive. Not everybody in TV land has similar experiences. But the important things you need to know about on the chart are a couple of things. The first is the top thing, and that is what Medicare pays for. And it pays for the first 60 days. There are deductibles, and depending on your supplement, it may or may not pay those deductibles, or it may pay some of them. The rich plans pay all the deductibles, so you go to the hospital, they don't pay anything. The not-so-rich plans, the rich meaning their premium is how much you pay for the plan, the benefits. The not-so-rich plans make you pay these deductibles. But if you look at the chart, they aren't that huge. But the critical piece is this. Medicare operates under something they call diagnostically related groups. So that means if I go to the hospital, anybody here goes to the hospital, and if you're on Medicare, they send the information in to the Medicare database. And the Medicare database says, how many days was Dick at Sacred Heart? And what was he admitted for? And they do a bell curve of Dick's days at Sacred Heart. And they say, Dick broke his leg. His average length of stay was 4 days to get healed and get out. So if I go to Sacred Heart, Medicare will pay me 4 days. And they call that a diagnostically related group. So I go in and they say there's a foot group, a leg group, a head group. That's oversimplified, but that's essentially how they do it. And if I go in and I have an injury within my DRG, Medicare will pay the hospital for the number of days within the DRG, and then it will stop. Many of you have hit this wall, right? You go to the hospital and they call you and they say, we're going to release your husband this afternoon. And you say, how can this be? Last time I saw my husband, he was incontinent. He didn't know who I was. He was in a lot of pain. How can you possibly release him? And the answer is, this isn't a question-answer session. He's going to be released at 2 o'clock. Where would you like him to go? And what's happened is they've run out of DRG days, right? They're done. And the older you are, the more likely it is you are to run out of DRG days because there are 2-year-olds in Medicare. So all these kids skew the curve down. So if you deal with older friends, older people, you will know that many of them are released while they're sick because they hit the end of the DRGs and they're out of there. And there are a couple workarounds, but the most important one is, if you kind of read down the middle of the page, it's the skilled nursing workaround. And the skilled nursing criteria or gatekeeper is that I must spend 3 midnights in a hospital and be released for the condition for which I was hospitalized to get nursing home rehabilitative care. If my DRG is 2 days, I won't hit the 3rd midnight, right? And I won't get this benefit. The other problem is one of the little games that hospitals are doing now with the help of Medicare is they're not admitting patients anymore. They're admitting them for observation, right? Observation is not a disease. So if I'm discharged from the hospital to the rehab facility and my disease is observation, you're not going to get anybody paying for that because there's no such thing as observation. So there are some workarounds you need to be aware of. And the first one is when a loved one is hospitalized, you need to call the hospital and say, have they been admitted? Are they admitted to the hospital? And if they say, oh, they're here, you want to say, no, no, no. Are they there for observation or are they admitted? And if the answer is observation, you need to call the physician, the primary physician, and say, my dad needs to be admitted. And dad's in there for a reason. He's not there looking at television. He's in there for a reason. And they'll then diagnose a condition which will start the DRGs, right? Start this time frame running. So you can hopefully get past your 3rd midnight. So that's kind of a critical piece. If dad is in there for 2 weeks, I've had people in the hospital for 2-3 weeks on observation. They get no care when they're done because it never attaches. Medicare never attaches. So you have to be kind of vigilant about this. So the person is then discharged, and then they go to the skilled nursing facility. They have to hit the 3 DRG days, and they have to go in there for the same condition for rehab, which is common if somebody's in there for a while. But it has to be the 3 midnights, and sometimes that's an issue. And when they call you and they say, we're going to discharge your dad tonight, and there's no way in the world your dad's ready for discharge, you got to go back to the physician again and say they're going to discharge dad, and he's too sick, re-diagnose him, and physicians often will do it. They'll often say, okay. And I've also had that conversation with hospital social workers where I say, you're not going to release Dad. He's way too sick, and we both know it. And if he's released and he goes home and catches so much as a cold, this family will sue you guys. This won't protect them from malpractice. So it's like, you got to decide how you're going to handle this. And then I say during the stunned silence that follows, the family will pay to keep Dad there for a few more days. Family would. Every family would. It's like a no-brainer, sure. And what happens in the real world is the hospital administrator, all these social workers have a little red phone, they like to the Kremlin, and they pick it up and it's to the head of the hospital, and they say, help. And what you want to say in this discussion is, we don't care about the DRG days. We only want our dad to be well. And when you say that, you have to say it. When you say it, it tells them you understand that this system is not about health care, it's about money. And you've just leveled the playing field. And in all the times I've done this, I've never found a family billed, ever. If you got a bill, I tell you to pay it. But what happens is that in the middle of the night, mysteriously, a hospitalist shows up and sees your family member, your father, and finds that he has some new disorder of some sort and re-diagnoses, and you get past the 3rd midnight. I mean, it's unfortunate we have to go through this, but you have to fight a little bit because of the way the system works. If your dad had a big stroke and he's in there for a big stroke for a week, you don't have to worry about any of this stuff. But if he fell, they'll try to discharge in a shorter period of time than may be appropriate, and you have to push back. The hospitals don't, they know it, they get it. The doctors hate this system, really. The hospitals hate it, the doctors hate it, because it results in under-treatment for people that are older and need more care. Once this has all happened, and now you're at St. Luke's, and you're being rehabbed, St. Luke's decides at some point along the way that you're no longer eligible for skilled care. And what Medicare does is for skilled care. Skilled care means doctors and nurses and actual rehab, OT, PT, that kind of stuff. And if you have dementia, at some point you will no longer be able to get skilled care. Why? Because when this physical therapist comes in to see your mom and says, okay, Betty, do this and do that, and Betty does these things, and the physical therapist walks out and Betty turns to you and says, who is that? The problem is Betty can't sequence nor remember what she was told to do, so she's going to, in the medical world, she's going to plateau. She cannot get any better unless you had a physical therapist standing there all day long having her move her arms and legs, right? And so when that happens, they will stop the therapy, and they call that decertification. So they'll decertify Betty. They'll say no more care for Betty. My mother's name was Betty, and my problem wasn't that. My problem was my mother hated physical therapy. So she would go to the hospital. She'd fall, go to the hospital, and they'd call me. And during the period of time she was living at Covenant Shores, I was an MVP Gold Alaska flyer. They would call and they'd say, help, and I'd be on the plane. And I kept her at home with 24/7 caregivers for a while. And then, like, Susie wouldn't show up at 2:30 in the afternoon. She'd call me, and she'd say, Dick, Susie isn't here. So I'd call the agency, and I'd say, where is Susie? You've all been through this. And they'd say, we don't know. What do you mean you don't know where Susie is? So then I could drive to the airport, get an airplane, fly to Seattle, rent a car, go to Mercer Island, get everything all cleaned up, get my mother under control, and wait for Freddie to show up, and then I'd fly back to Spokane. And so when she was in the nursing home, I did a lot of this too. But she would go to the hospital, and we'd get, everything under control, whatever had to be done. And then the physical therapist would come in to help her, because she is eligible for physical therapy days. She'd been there 3 days, plus. So they'd come in, they'd say, if you went by Elizabeth, they'd say, hi, Elizabeth. And my mother would be reading a newspaper, and she'd say, who's that? And I'd say, I don't know. And she says, it's the physical therapist. I don't do physical therapists. Okay, Mom. And so the woman would say, Elizabeth? And she'd say, I do not do physical therapists. The woman never introduced herself, but my mother knew. And, of course, had she done physical therapists, it would have saved us, over the time of this, $100,000 in Medicare. It would have helped with the rehab, right? But, oh, no, not going to happen. So you never know who you're dealing with. But this thing here is the Medicaid chart for Washington, right? And if you remember, I talked about a CSRA. That's in the upper right-hand side of the page. This is how much the well spouse gets to keep. And if you are in care in the community, anywhere but in a nursing home, the well spouse gets to keep $53,000. If the ill spouse is in a nursing home and your assets are sufficient to justify the higher number. They take your total assets, they divide by 2. Then the wealth spouse gets to keep $117,240. The stuff on the left does not count. They do not count your house. They do not count your car. They do not count prepaid burial plans or burial plots. And if you remember, I talked about ways you can create eligibility. One of the ways you can create eligibility is to buy a house. So sometimes Medicaid eligibility is simple. People come to me and they say, you know, my husband's in the nursing home, and we're now being decertified. What are we going to do? And I'll say, what do you got? And they'll say a house and a car. What do you owe against the house? $50,000. What do you have in the bank? $100,000. If you pay off the house, your husband will qualify for Medicaid, because the house, which is on the left side of the page, doesn't count. So sometimes Medicaid eligibility is simple. I've had people buy Mercedes. To me, that's a bad investment, but I've had them do it. You know, if you buy a Mercedes, it's an exempt resource. When I first was doing this work, Medicaid is social planning. When I was first doing this work, the rule said the car had to be purchased in America. Come on, you know, it's the car lobby. And now it doesn't say that because cars are made everywhere. So, but you can buy a new car. It's not uncommon for me to meet with somebody and they've got money and they drive an old, you know, 1972 Nova, Chevy Nova, and they've got $20,000 too much. Now is a good time for an Impala, right? Buy the car. And they look at me like I'm on fire. Buy the car, and that will qualify your spouse for Medicaid. Otherwise, you're going to spend it down. And, you know, when I deal with seniors, I've learned that especially the older ones are sneaky. And they'll go into the car dealership, and they'll tell the car dealer about their sick spouse. And I had one woman who had the car guy in tears, because his mother had Alzheimer's, and her husband had Alzheimer's, and he had him in tears. And he went back to the factory, and he got her this fabulous deal. It was a Ford, I can't remember the model, but a fabulous deal. And she came back, and she proudly showed me how this was a great deal, but it wasn't enough money. She had to spend down, right, to create eligibility, and she had connived this guy into such a great deal that she wasn't spending enough money to be able to make it work for Medicaid. So I had to go back and say, give him the rest of the money. And he called me and said, are you out of your mind? Just do it. Will you just do it? Because otherwise it's going to cost her $10,000 in care, you know. Just take the extra $5 and do what I tell you to do. I was very complimentary because she did a good job on the deal. But the other thing they don't count are some annuities, and this is important. Annuities that look like a defined benefit plan are exempt. Medicaid does not count retirement plans. And so, for example, if I retire from the city of Spokane and my income from the city of Spokane is $2,000 a month and I need Medicaid, they will take the $2,000 from me to offset against my cost of care. So if my cost of care is $8, they'll take the $2 and they'll pay $6, right? But they can't cash out the plan. They can't call the city and say, commute the value and send Dick the money. So he won't do it. The same thing applies to these annuities. Dick can buy a defined benefit plan. So I can take the money in excess of these ceilings and I can buy a retirement plan that is irrevocable, that pays monthly, it must run for 5 years. It basically is a defined benefit retirement plan. So I can convert assets into income, and I can do it with a good deal of money. So for people that look at this and they say, we can never qualify for Medicaid, you probably can. We can do it with 401ks, we can do it with IRAs, and we can do it with cash. Now, for many people that have a lot of money don't want to do this. But if you have $300,000-$400,000 in this world, and if you have no choice but to spend it all until you get down to $50,000, the annuity starts to look like a pretty good idea. So in this case, Karen can be in the care facility. Dick can take our money, put it in my name, make it separate property, put the house in my name, put the cars in my name. Then I can buy one of these retirement plans for all but the $53,000, and Karen will go on Medicaid. And the retirement plan will pay me monthly for the next 5 years. So I can take the funds and I can put them in exempt resources and create eligibility that way. That applies in all states. Everybody. That applies out there in TV land. That applies to all states. And there are different kinds of these things. So the next page talks about how income works. You can look at it. The last thing I want to talk about, and then I'll take questions, is this. What if you give away your money? What happens to you? really bad things. So here's the rules on Medicaid. And the same rules apply to SSI. Most of my clients are not on SSI, some are. But the rules on Medicaid are this. If I give away money to anybody but a spouse, got that? I can give Karen all the money in the world, nothing happens. No penalty. They don't consider that a gift because it's her money and my money. That's not a gift. But if I give my daughter Wendy money and I apply for Medicaid, the effect of that will be that I made a gift to my daughter Wendy, and Medicaid will take the value of my gift and divide it by 267, and that'll be the number of days of ineligibility I will suffer as a consequence of the gift. And I can't get Medicaid until that period of time has run out. This is the same. Every state that's out there has a different number. So Idaho, you got a different number than Washington. This is our number. And that's the number of days of ineligibility. So if I give Wendy money, the penalty, they'll impose this penalty, but they don't impose the penalty until I actually apply for benefits. It's not when I give away the money, it's when I ask for help. So if I give Wendy $200,000 today and I don't apply for Medicaid for 4.5 years, when I apply for Medicaid, then 4.5 years from now, they will impose the penalty going forward. So instead of waiting 5 years, which is what they call the look back, I might have to wait 8 because I made the gift and I waited to apply, and the penalty doesn't start until I actually apply for benefits. There's one kind of overriding rule, and it's called the look back. And the look back says that if I make a gift and 5 years have passed since the date of the gift, they don't count it. So if you've given your kids the lake cabin and it's over 5 years gone, they don't count it. They don't care. They don't count it. If you reserve a life estate, they count the life estate under some circumstances, but they won't count the gift. So if you gave the kids the lake cabin 6 years ago and now you need Medicaid, the state doesn't even recognize it. It's like it flew off the radar screen. So that's how the 5-year rule works. But you can expand the 5-year rule by not planning right and by making a big gift and waiting 4.5 years and then applying, and then you'll be out 8. Because of the penalty doesn't start until you actually apply for benefits. That can be just a catastrophe for people. And that's illustrated on these charts. If you are on Medicaid, what they do basically is they take the income of the disabled spouse and they use it to offset costs of care. The well spouse is allowed to have a certain amount of money, so you're never impoverished. If you look at the income chart, you can see that the well spouse gets $19.39 in the state of Washington no matter what. No matter what. So if Karen and my income is $2,000 and I end up in a nursing home, Karen will get 100% of our income and I will get Medicaid benefits. If I'm home, I get to keep more of it because I have costs of care related to the home life. So if I'm living at home and I'm on COPS, COPS sends in caseworkers to help take care of me at home. I get to keep more. So it's designed for me to be able to live at home. But it guarantees the well spouse has to get at least this much money, sometimes more. And you can see those, if you look at the bottom of the page, you can see how much more it is. But if, for example, I'm living at home, Karen and I get a $721 additional on top of that, the CSRA of $19.39, and if I'm single, I get $958, so I can stay home before they start to deduct from my money to offset my cost of care, and that offset is called participation. So that's kind of how it works for income. So most people, when I meet with clients, they say, I'm going to go broke. I want them to do. Well, my husband's money is going to go take care of his cost of care. No. Your husband's money is going to come to you up to $19.39, maybe more. And then whatever's left over, it might be used for cost of care. And it depends on who has the most money. I had a client who came in, and the husband was retired full bird colonel. His income was $7,000 a month. $7,000. Another one had $8,000 a month. And I said to him, how did you ever get this kind of retirement? He said, well, World War II, B-17s, Korea, Mitchell's, I go, okay, never mind. And his last job was as a FAC in Vietnam. I mean, he's lucky to be alive. And he said to me, I can't understand why anybody wouldn't join the military. Look at this great retirement benefit. I said, well, 4 wars, being shot at in a Piper Cub, I can understand why people might not want that kind of work. But so he has this big pension. And his wife is sick. the rule for him is the well spouse gets to keep 100% of his income. 100% of his income. Or this trade-off for the other spouse. So it's 1939 or 100% of the income. So this guy got to keep all $8,000 a month. His wife's Social Security was $300 a month because all she did was follow him all over the world while he got transferred, right? So her cost of care was $300, and he kept 100% of his income because it was 100% of your income or 1939. If you turn it upside down, it's not so pretty. And unfortunately, guys, the men are usually the ones that are sick. And so in that case, had he been the sick spouse, she would have gotten 1939, and all the rest of his money would have been offset for cost of care. So it depends on who's got the money and how it works, but you're guaranteed at least $2,000 a month. So that's a basic primer of Medicaid and state planning in the state of Washington. Who has questions, he says, taking a deep breath. Wait. You have the question rules here.
My husband just died 2 months ago.
Wait a minute, she has to give us our rules.
Nope, we'll take one here,
Okay, here we go.
and then we'll go around to our other side.
Okay,
So do one question.
fire away. Borrow my lavalier if you want. Use this, yeah. You can have this one, I'll use that one.
Thank you. Okay.
Thanks. My husband died 10 months ago, and one of his insurance policies, he had not put a beneficiary on it.
Mm-hmm.
He only had his name on it. And the insurance company said, it's not my money, so they don't want to give it to me.
It should be payable to the estate. The insurance company will lose.
Okay, that's what they say. It's going to have to go to,
The estate.
yeah, and then I'm going to be a trustee, and that's the only way I can get the money out.
Well, yeah, you have a living trust?
We have a revocable
Living trust.
Yeah.
So the answer is that probably it will go into the estate. And if the revocable living trust is set up so that only the excess over $2 million goes into the family trust, the credit shelter trust, you should be able to get at it in your survivor's trust. If your trust is designed so that everything goes into the credit shelter trust first, then you only get the income from it. Depends on the trust. But having said all that, everybody should understand that there is no trust I cannot break.
Okay, but we're both on the trust.
But he's gone.
Yes.
So you're the surviving trustee.
Yeah.
And within it, there's probably a survivor's trust. And that's probably where this money will go. So it'll pay to the estate. Here's the problem, though. For all of you who have living trusts, this is the perfect storm for lawyers. Here's the problem. In order for a living trust to work, it has to own everything that you own. It's like a corporation. It has to own title to your house and title to your cars. So when you die, the trustee can pass that property on to your heirs, be it your spouse or your children. If it's not in the trust when you die, the only way to get at it is through a probate. So the idea, what you did when you bought the living trust was to avoid a probate. But now you're going to have to go through a probate to create an estate account to have the will pour it over into the trust. Yeah, it makes lawyers very happy. But I can tell you honestly, I would say 90% of the people I deal with living trusts go through probates because they buy stuff or they name an estate the beneficiary, and if he named the trust, it would have been fine. But he didn't. So the only way to trap that money is to start a probate and then have the money pay into the estate, and then you have something called a pour over will, which will pour over into your trust to avoid probate. So you have to do a probate to avoid probate. It's not hard to do. It's not expensive. Probates in this state are $1,000, $1,500. It's not a big deal, but it's unfortunate that you have to go through all that.
Yeah. So, once they give me the permission, then can I take it all out at one time?
Yeah, you can take it all at once, but you're going to have to do a probate to get it into your trust.
Oh my God.
That's the problem. You got to go see a lawyer. Sorry. It's good for the economy.
Okay, we're going to go to the different sites real quick. Anchorage, Alaska. I'm going to have you tell me how many people and let us know if you have any questions. Chihuahua, Providence, St. Joseph.
Well, they're all muted.
Yeah,
You're all muted up there.
And okay, well, if I miss you or and I get to the bottom, just holler out. Clarkston Tri-State Memorial.
They're all overwhelmed.
It's a lot of really good information.
Yeah.
Coeur d'Alene Kootenai Medical Center. Some places may have timed out, so they might not get to talk to us, their system. And if they have timed out and for some reason it's not working, you can call me and I'll get the information to you. Colville, Providence, Mount Carmel. Because I see people in our videos over there.
Can you hear us? Nobody? Okay.
Okay, yep. And Dayton, there was nobody in Dayton. And Miles City, Montana. We're cutting into their fun weather time is what happens.
That's it.
Moses Lake.
Cindy, there's 6 earlier and there's 5 of us presently. Great program. No questions, however. We'll you can email those Medicare and Medicaid talks out if we request it. Is that what you
Absolutely.
said?
I have
Okay.
email format for both of those, I believe.
Great. Thank you very much.
Thank you so much. Pendleton. And Pullman Regional Hospital.
Yes, there's 4 of us here, and we don't have any questions at this time.
Thank you. And, okay, any more questions in Spokane? Okay.
Yes.
When you were talking about the, sorry,
It's okay.
usually I'm loud enough.
It's got to go around the TVs here.
When you were talking about the gift and the 14,000, can that be other than money? Can that be a car? Can that be like farmers, machinery, things like that?
Sure. Question is, can you, for the annual exclusion gift, the $14,000 per year per person, what can it consist of? The answer is it doesn't matter as long as it's a present interest gift, meaning you give it to me and I can spend it or use it tomorrow. So if you give me cash, I can spend it tomorrow. If it's a car, I can drive it tomorrow. That's called a present interest gift. If you put it in trust for my college, you wouldn't get the exemption because it's not a present interest gift. So it has to be something I can spend tomorrow. And all it means is you don't have to report it to the IRS. But you can gift up to $5,346,000 without tax. So it's not a big deal. So if you called me and said, I want to give my 2 children $25,000 apiece to help my grandkids or something like that, can I do it? The answer is sure. You can give them over $5 million if you want. You just have to file a gift tax return. There's no tax until you exceed that $5 million ceiling.
Thank you.
Sure. Yeah, and your accountants can do these. They're very simple. They're called Form 709s, and then you just do them in your 1040s. It's not a complicated return. So the fact that you have to file a return isn't a good reason not to do it. If you want to send your kid to Stanford, send your kid to Stanford.
Do we have any other questions? Yeah.
Two questions. First one deals with long-term care policies, how that fits into this whole thing. I saw it on your chart here, but I didn't understand it. The second thing is, I'm sure that we have to go see a lawyer to get this thing fixed up, but does a lawyer like you in your company have a form of information that I have to carry to the lawyer so that he can help me in the best, most efficient way?
We use a form. When people come to us, we send you a form, and the form traps all your asset information and other information. So when you come see me, I've got it all, so I know what I'm dealing with. So yes, we have a form. Most lawyers have an intake form. So if you call a lawyer and say, I want to come in and deal with these issues, most lawyers have an intake form. The trick, though, is you got to go to, if you're dealing with disability, you've got to go to a lawyer who does disability work. And that's the critical piece. There are lots of lawyers out there. Very few of them do what I do. And so it's important to find people that specialize in this. And the best way to find lawyers is to ask other lawyers. The same way you find doctors. You ask other doctors, and the doctors will say, this person's really good, this one, and go to that one. That's lawyers do the same thing. So if you said to me, I'm going to go see so-and-so, and I will either say to you, great, or you might want to go see somebody else. So you want to make sure you're going to somebody who has skill sets around these issues. That's important. The long-term care is helpful, but rarely is it terribly helpful is the best way I can put it. Long-term care insurance will help you for almost everything but skilled nursing. The problem is skilled nursing is going to cost $8,000 to $10,000 a month. And unless you have a giant long-term care insurance policy, it's not going to offset the cost of care. So, and most of my clients come to me and they'll say, my husband has